Apia could be made it clear to Bawumia and Chairman Wuntumi and Bawumia Yere. And in the you know to say Chairman Wuntumi will be jailed because the evidence the Attorney General provided and I know it didn't do.
Well, basically, while we're drawing the services, he is no more the lawyer for Chairman Wuntumi.
Shamachi Shra Yahuwa ila henu Yahuwa a cat.
You see, when this thing started, I told you guys, I said, you guys are playing with fire.
Na make sure Wuntumi nyansa wa Ghana ha. Ebe no mama.
Kwa champagne.
So Enunwe Bufo na Apia Kubi Babo Ntibeka say he is not going to be the lawyer of Chairman Wuntumi.
The lawyers of Chairman Wuntumi Pede will save in, but it is actually getting a bit more interesting. We'll put some surprises here. It is trending on social media. But more than a video from WhatsApp area. Check your comment section straight to the news. Now, Ebowa. Every lawyer in him had often delay tactics. Now, this is as a result of the legal framework and some would but Chairman Wuntumi know over the past few days in the yats some about the judgment or about one case no do. So this case involves around some 30 million sekebia chede wa buy a bit of some issue could do a plea bargain be some baby. But the trending issue no babaye there. The lawyers were pade. Now, a lot of people are not seeing it. They are trying to lie to the public. Ono and a month for baby now they've been able to see today. Now, Seboya, say actually the core legal framework, which is in Rule 87, which is clause 4 now. Otumuchira there, Ghanaian court no, it can legally force lawyer be there. Case na or handle no on stay. Every client to be out the Nasamba court to be or lawyer. Inti lawyer no is on the case for the client. Inti Rule 87 clause 4 no court no botum no wash obi there on stay on the case even if lawyer no pad option no fear some no. Now ono no chere there how come the lawyer etuma handled a case from all the beginning na see say we do tum na bro na Apia Kubi the lawyer Apia Kubi pad option no fee Chairman Wuntumi as the lawyer as a legal affairs team. How come? It's because they want to do something called delay tactics. Now, Chairman Wuntumi the lawyer is trying to withdraw right before the judgment is delivered. Now, how there's the delay tactics or what seven more. And now, Attorney General, to fight this withdrawal. But at this catch is the catch in the say in your maybe in war. Say the first part in there. The moment court in the back of some lawyer Apia Kubi and some name phone to it means we are refusing the withdrawal. Meaning there, it can backfire very, very sharply. That is one thing I'll do. The moment I wear a delay tactics, it will not go in favor of anybody in the beginning. But this is what AJ can do. It's a moment coming chair one makakra. So if judge ne kada no, there ma assembly stay in favor if you want. Defense can immediately appeal that ruling. Now we file a petition. Now I try there. They would try with the whole case up. No, we try some legal battles. Now we try. Now we achieved the delay. In the no chere, judge will be stuck in the middle. So anytime he be a lawyer, na say okay suda. Na say a handle for what client. The moment a judgment say baba pass na kare e pedi jina nchana. So court no to one force me jina some no still as the lawyer. Na say kare still dem pedi be jina. Ebutum no a freeze case no wo high court ho. Na wa ngasa as a lawyer na appeal them as some high court for what can no. Me wan nya meaning the assam still delay. That is what it means. Now, since they will deal assembly nine there, akakrama lawyers work on vacation period. Nkoma nine. It is a wako vacation period na. Ye be said the one son baby mana. The point is what to PM obro the vacation period. I have some say obro beyond a certain period bia. I have sometimes a lack certain basis. Into either there, the judge may handle it again, or the judge may give it to another person's jurisdiction. Now, if the second part in there, say if the judge so allow the as some yellow try for him because he's on the yate. Yate there first one man don't feel you home. But say judge in not doing the okay. Say a pede a sor or ye Chairman Wuntumi as lawyer say it's runty and pede about you as some no that. That also mean there, or the chama won't to me, or the courts manabir, ma kafanankas and the lawyer, which means it can take months for even the lawyer to come in. The lawyer in the Subama, while Tonobona will read through the files. And this is going to take months. In the chair, as a worry is to just to make sure that as I'm watcher or quarter. Into either left or right, no. Chede wopede woma assembly or a foolish case. But then this is the bigger picture. The bigger picture in there, as in wopede way delay tactics. But as in fact, because Chama want to me who there plea bargain or casamate exam bank no in some semi worker in the past. And the shocking part in there, can Japan so I can send me in time past there for the sake of that Chama want to me or supported by Omiano. Adibi besi wana kwema untu mintine kruma. Chama want to me in the Ashanti region is trying to stand for Oye MPP chairmanship. Na azi obutu wa suffice na. Knowing so well there, no friends are working and it seems they are going after him. This is getting a bit more controversial. Into the last part, Chama to Minankasa personally obotu wa there. Oba fire Chama appear kubi. No jede say judge no say yimpa no say lawyer no say the asam no or handle bill. Na say lawyer court no say the debi jina asam no do. We are not giving you the opportunity to leave your client. Chama to Minankasa to exercising constitutional rights. Now I sack a lawyer no. So sack a lawyer now meaning they will compel the judge and they'll take some days. But the point is, my the cheddar you are doing delay tactics. It's a job mama attorney general someone there. Or identify all the nitty-gritties of Uncommon. No, we are catch a judge there. That man me, na that man a year in time past no. Or cheddar petty delay court. The moment obo delay court no cheddar what we sue even obo to one sense we sue Chama to me for contempt no delay. Cheddar petty waste amount for one time. Onupo mama Chama to me now so chino wakwenyim. But there is something that a lawyer Amaliba or Abotuga, and that man somebody very very surprising. Apia could be so about the lawyer of Chama to be so about Kasembi. In the Chelsea, Chama to be maybe Obejnebiano. He's getting himself disgraced. I've been telling some more about it, but Mazana share video in the form of your WhatsApp. But Mazana young question video in the area, you're composendo.
The next thing is that I want to indicate here that people are misconstruing this application or motion for plea bargain to mean that the Attorney General is entertaining Wontumi. That's how some people have read. The Attorney General has no hand in this matter. The plea bargain provisions, when they were incorporated into a Criminal and Other Offences Procedure Act, it allowed the accused person or his lawyers to apply for plea bargaining. It's a negotiation. It doesn't mean that the Attorney General has accepted. But this must be brought to the attention of the court. And I think that's what was done. Notice was filed. The next thing is that when they appear before court, within 30 days of the commencement of, or the filing of the commencement of the bargaining, rather, they must conclude within 30 days. If the parties fail to conclude, they come back to court and the case continues. So at this point, the Attorney General has not accepted anything yet. I am making this statement for people who don't understand to think that the Attorney General is in cahoot. You get my point? With Wontumi. It is a provision that allows the Attorney General, the accused person or his lawyer to take advantage of. It's more or less ADR in criminal matters. You know, in civil matters, we have ADR. This is also ADR in criminal matters. There are some offenses that cannot be a subject matter of plea bargaining. Murder, treason, all those rape. Ones. They have listed them, rape. So I just took my time to make people understand that Attorney General has no hand in this matter.
Yes, but I mean, there's a public interest element in the sense that prosecution serves a certain purpose, and sometimes recovery may not necessarily meet the ends of justice in the eyes of the public. I don't know if you get that aspect of the conversation.
I'll get to that. Now, plea bargaining allows the accused person to plead guilty, and that's why I disagree with the lawyer when he said that it doesn't mean we are guilty. It allows the accused person to plead guilty in exchange for threats.
Who said that? Who said that? Did I say that?
No, I didn't say
No, not you. And the appeal. And the appeal.
Are you the lawyer for Apia Kube? If you want, go and ask him to take you as a lawyer. It allows for threats. One, charge bargaining, which is accepting to deal with a lesser offense, charge bargaining. It deals with sentence bargaining. When you are going to be sentenced, the agreement filed will say that give him 20 years or give him 10 years, and the judge must go by that. It deals with the third one is non-prosecution bargaining, where there will not be prosecution. Now, I don't know which of the three. Maybe when they get to court, we'll know. But I am going to speak in a way that will favor both sides. Wontumi has so many cases. It is sensible for his lawyer and Wontumi to agree that, look, what is happening to you, can we just plead guilty and then you pay the money? And then that would deal with sentences so that maybe there will not be sentences or there will be minimal sentence or that kind of thing. Then for the state too will say that, but this man has got 3 cases. Attorney General will say that my case is strong in the forestry case, the mining case. I am sure he will go in. But let me then take the money here for the state. Which one is good, which one is not good, I'm not about to say it. But I am just telling the viewers that these are the permutations that both sides will be doing. Your public interest question will now fit into this jigsaw, which is, should the state say that let's take this money, use it for development, or he goes in the mining case, and what this will only do is to add more years to him. That's what it will happen.
Okay.
So the state will say, what will I get if I jail this, or the court jails this person 50 years, and yet there's money lying? You know that there was this issue the Attorney General failed to do, and I criticized him for that, these ambulance cases. When the supplier said they were going to pay, I sat here and said that the decision by the Attorney General was wrong. Because as a poor country, if they are paying back your money...
You confuse our viewers, the former Attorney General.
The former Attorney General.
Yes, the former Attorney General.
Yes. Now, the Rugo or the Ricam, everything now, we have lost everything.
Okay.
So I think that the permutations that will be done by both sides make sense to both sides.
All right. All right.
But let's wait and see how this negotiation will, whether Attorney General will accept or not.
Law is growing, so we should be patient to learn the law, even in situations of difficulty. But we relate to precedent at all times. And you remember that the civil procedure rules are different from the criminal procedure rules as we operate in the courtroom. But in the case of Republic versus Dufour, it was determined that case management, which was part of civil procedure, be adopted by the court. And since then, we have all adopted case management, which is part of civil procedure. And in law, whatever is excluded should not necessarily be included, but it does not also mean exclusion in another area of law. So once the courts have adopted part of civil procedure, there's a presumption that other parts would be appropriate if invoked. And in a recent case of Mrs. Gertrude Tokonu versus the Attorney General, counsel wrote a piece of letter to inform the court of his withdrawal of services. But the court considered that inappropriate and inadequate, and therefore requested a proper procedural approach. Learning from that, and in the response to counsel, then the court said that this is inappropriate. And the court did not emphasize it is inappropriate in civil situations. It said it is inappropriate to address the court this way. So, learning from that direction, we also believe that as a court of records, we should properly inform the court of the reasons why we are withdrawing our services, and also inform all parties of such reasoning. Indeed, part of the argument of the court was that we did not serve our client, the accused person. And it is demonstrable, even in the court, that notwithstanding our intention to withdraw, we have stayed glued to our client even till today. And even on a day like this, we announce ourselves as representing our client. So the withdrawal of representation would be subsequent to today's action, not before, for